It's nice to see a good crowd here this morning. I hope everyone had a nice weekend. Welcome to the first seminar on intellectual property, which is brought to you by Mackey Law. Brief introduction to myself and to the firm. My name is Robert Mackey. I'm an engineer from University of Waterloo, also a lawyer. I started my career in Silicon Valley as an engineer. Worked there for several years for a telecommunications company, more passive fiber optics. Very interesting career. Did a lot of work on manufacturing and software, both in North America and Southeast Asia. Returned to Canada, went to law school, worked on Bay Street, and basically paid my dues there and moved on more into the startup world. I worked for several startups and larger companies such as BlackBerry in the Strategic Alliances Group. I initiated the intellectual property portfolio for a company called Maluba, which received funding from Silicon Valley VC, and eventually we had a good exit with Microsoft for an undisclosed sum. And I learned an awful lot about intellectual property in that role and how important it was to develop the portfolio strategically from an early stage. Of course, if funding is available for that kind of thing, and because we did it correctly from the beginning, it made the company far more attractive to Microsoft, and we got some premium value for that acquisition. Anyways, I'm going to move right into the presentation. I'm going to try and keep it at a high level and relatively brief, and hit the points that hopefully are of interest to the people joining the call today, mainly from the technology industry. And at the end, we'll have time for Q&A. And I just would just say one thing, because I'm a lawyer, we have to worry about risk and so forth, that I'm more than happy to answer any and all questions if I can. But I have to answer them in a general sense. I can't answer specific questions. So if you give me something specific, I'm going to have to, give a caveat and then make it a general sort of piece of information about the law and nothing about your specific circumstance. Obviously, the relationship, if it's possible, we can have more detailed discussions in another forum or individually at another time if you need some specific advice. Okay, so I'm going to begin the presentation right now. Hopefully everyone can see my screen. You don't have to look at me anymore. Okay, so welcome to the introduction to intellectual property, and I hope to cover the main points and make it clear why you should at least care about this as you move forward with your business. Okay, what is intellectual property? I think most people have a sense of what IP is. I'm just going to refer to IP for the rest of this presentation. But a more technical definition is intellectual property is a broad categorical description for a set of intangible assets owned and legally protected by a person or company from outside use or implementation without consent. What that really says is that IP is intangible in the sense it's non-physical, and they're creations of the mind. And they're given protection by various governments on a national jurisdiction. And that allows you to treat it like normal property. And what that means is you can lease it, you can license it, you can prevent other people from using it, and you can exclude them from the property just as if it was real property. Of course, it is different than actual tangible real property because selling, sharing, licensing IP does not really diminish supply in the same way that selling, actual widgets or real property would diminish the supply. So there are some special considerations of intellectual property that are different from actual real property. For the most part, it's a creature of statute. All that means is that it hasn't been created by the courts. It's been created by governments in legislation, except for something called passing off, which I can get into later. But for the most part, patents, trademarks, copyrights are creatures of government itself. And importantly, as I mentioned before, IP is national in scope. So if you have a copyright, you have a trademark, you have a patent, or so forth, they are good in a particular country. So you could have a US patent, which is not enforceable in Canada, or vice versa. Of course, you can get a patent in many different countries for the same invention, but if you want to protect your patent or your idea in a particular country, you have to get the actual registration for that type of IP in that particular country. We're going to focus mainly on the United States. Okay, now that we've covered what is intellectual property, let's talk about why it's important. I think most people will know this, but the most important thing here is that often intellectual property is the most valuable asset of a technology startup, or for any technology company, that is. Protecting intellectual property can be essential to obtaining venture capital funding. It maximizes company value for that financing, whether it's venture capital funding or otherwise, and also maximizes the company value for the hope for eventual exit by an IPO or an acquisition. It prevents competitors from unfairly competing with you. What that really means is from stealing your technology. It can also be a reward for employees through incentives or to establish themselves as inventors. This is particular for people that are interested in research careers. And I personally think it's good to allow people to get recognition publicly for their inventions and to help them along their careers, whether it's with your company or with as a trusted friend and contact in the future. And something I have this in bold here is IP can be used as a shield in the event that you're ever sued for infringement, but it does not have to be a sword. You don't have to stifle competition. You don't have to write cease and desist letters to people that are using similar technology. But in the event you're ever sued, for something, or there's ever a positive negotiation with licensing, it helps to have your own IP protected, because you can get better terms in terms of settling, an unfortunate lawsuit, or in terms of getting better terms on a licensing deal. Important types of intellectual property. I think, again, most people know this. You've heard patents, trademarks, copyrights, trade secrets, and industrial designs, which are referred to design patents in the United States. I'll go through each of these briefly, while at the same time concentrating more on patents, because that's more applicable to the average startup company. What is a patent? I think most people, I got to stop saying that every slide. I think most people. What is a patent? A patent is essentially the protection for an invention that is new, useful, and not obvious. Typical inventions that are patented include software, hardware, manufacturing processes, and possibly even genetic inventions. That's genetic modification. There's some commentary people may have heard about whether or not software patents or software is patentable, and I can say without a doubt, in the United States and Canada, software is patentable. The progress bar has been patented. Facebook timeline has been patented. Some simple LinkedIn screens have been patented. Amazon One-Click, which you can see the logo in the top right of the slide, has been patented. Bluetooth is subject of 13 different patents, most of which are owned by Ericsson and most of which are in the public domain. Interestingly, you see a little picture of a mouse there. That is the Harvard mouse. Harvard developed a mouse, genetically engineered the mouse gene so that particular strain of mice had a higher propensity to develop cancer. And they did this so that they could have a larger supply of mice in which to test and evaluate possible cancer treating drugs. In the United States, that was enthusiastically granted by the U.S. Patent and Trademark Office. However, it was not granted in Canada, interestingly enough, because the Canadian Patent Office and eventually the Supreme Court said that you cannot patent a higher life form. That's debatable whether that's true or not, but that's the current state of affairs in Canada. How long is a patent good for? Typically, it is good for 20 years from filing the application, and the process takes, I say, 2+ years here, but it can take anywhere from, I would say, just over a year to 5+ years. But in general, it's going to take 2 to 3 years if your invention is granted a patent. And how much does it cost? I think people are aware that patents can be very expensive. It doesn't have to break the bank. However, you can file a provisional patent, which is good for 12 months for about $3,000 and up. And of course, it's sky's the limit. If you want to go into multiple countries and get translations, you can spend hundreds of thousands of dollars for multi-country protection, which might seem a far stretch if you're a startup, but for certain inventions, it's clearly worth filing and obtaining a patent in the major markets: Canada, the United States, China, Europe, Australia, and most of Asia, for that matter. Trademarks. Trademark is a sign or combination of signs, such as logos, that are used by a person for the purposes of distinguishing the source of their goods from the services or goods of other people. Signs can include a word, personal name, a design, a texture. I didn't get into it here, but actually it can include things like smells, sounds, etc. And interesting thing about trademarks is they don't have to be registered. Registration has its advantages, such as proving that you used it before someone else does, but you don't have to register a trademark. I think it's advisable to register the most important trademarks, but certainly it's not feasible to register all your trademarks. How long is it good for? It's 10 years for registrations, but may be renewed indefinitely. Trademark is the only form of intellectual property which, in theory, protection can subsist forever. The reason that is the way it is because trademark law is not just there for a company to protect, it's there to protect the public. So if someone sees, Coca-Cola or Nike on a brand, they know that it's, it's made by those companies, or at least if it's not, they can be sued. And that provides a public protection, angle, as well as helping the company with innovation. And how much does it cost? Typically less than $2,000 for each of Canada or the United States. I would say it's even often less than $1,000. And it's relatively quick to obtain, often a year or less. Copyrights. Oh, let me just go back here. At the top, you see some logos. Obviously, the first two you're going to recognize. Those are just very, very famous trademarks. And you'll see an X through the Lego block. And that's just an interesting case because Lego attempted to obtain a trademark on its block. And what they were really trying to do there is get protection for a functional aspect, essentially get a patent forever, even though they called it a trademark. And the European Trademark Office said, no, we know what you're trying to do. You're actually trying to get patent protection forever. Your block cannot be trademarked. It can be patented, but it's only going to last for 20 years. So they refused the trademark application for their block. Otherwise, they would have obtained indefinite protection for something which is functional. Copyright. Copyright is the protection for any original literary, dramatic, musical, or artistic work. Covers a wide range of things: books, songs, films, plays, paintings, drawings. And most interesting for the people on the line here is it protects software code. I say even APIs. Copyrights do not need to be registered whatsoever. Registration also has advantages, but as soon as it's fixed in a physical form, in a way that can be copied, and doesn't have to be publicized, but typically it would be. Well, in the case of software, it often would not be the actual software code. Copyright protection subsists. How long? It's for a long time. You don't typically have to worry about that. Right now, it's life of the author plus 50 years after their death. Most countries, it's 70 years because there's an international convention on that called the Berne Convention, which Canada is party to. So soon in Canada, it's going to be the life of the author plus 70 years. If there's more than one author, which there can be, it's the last author to perish plus 70 years after their death. How much does it cost? It costs zero because you don't have to register it. Again, it does have advantages, and it's very inexpensive. I have a couple logos up there. You'll see the Android logo. That was a famous case brought by Oracle, who actually owns the rights to some of the Android copyright software, or software which has been copyrighted. And they sued Google for copying their code, particularly the application programming interfaces. The US Supreme Court found that you can have a copyright in an API function call if it's unique enough, the name, but it's hard to imagine, a function such as summing two numbers having a very unique name, but it's possible if you have a unique name and unique parameter names to copyright your APIs. But eventually the US Supreme Court found that Google's use of Oracle's software in the APIs was actually fair use, which was kind of a novel case in the United States. I won't get into that too much. To the right of that, I have a database symbol. Databases, the structure can actually be copyrighted if there's some unique skill and originality in terms of how the information is organized. And some countries, particularly Europe, actually have a special form of IP for databases themselves, but that does not exist in Canada and the United States. Industrial designs, they're also referred to a design patent in the United States, which will always say a design patent is really not a patent. It protects the design itself. It just happens to be called a design patent in the United States. What is it? It's basically a form of IP that protects the visual features. That must be visual, such as shape, configuration, pattern, or ornament, or any combination of these features applied to a finished article. That's an actual product itself. Applies to consumer goods, furniture, vehicles, any kind of consumer good, and electronics. And interestingly, typically industrial designs are not a form of litigation, but one of the most famous IP cases in the last 10 years was a case of Apple sued Samsung over the shape of their phone and the shape of their tablets. And it was one of the largest awards in IP history, over $500 million, I believe, because they found that, Apple's curved edges of their iPhone and their tablets was subject to a design patent, and it was protected, and Samsung had infringed that. So if you sell actual physical consumer goods, either to consumers or to businesses, they can be protected by an industrial design or a design patent. How long is it good for? 10 years in Canada, 15 years in the United States. Typically, it's quite easy to get. You have to submit your drawings. The examiner in the office will do a quick search to make sure it's not too similar to something that already exists or is registered. And it's relatively cheap, $1,000 to $2,000 in general, maybe a bit more, but it's relatively inexpensive. And the final form of IP to talk about today is trade secrets. Trade secrets, essentially information that has value that you keep secret. And it could be software code, it could be algorithms, customer lists, any kind of proprietary information that you develop that is not in the public domain can be kept secret. The way you protect a trade secret is you take affirmative steps to protect it via contracts, such as a non-disclosure agreement, employment agreements, and so forth. And in certain cases, actually physically separating certain information from people that don't need to know. How long is it good for? It's good forever, as long as you take the steps to protect it and it's not disclosed to the public. How much does it cost? I would say, it costs some money. You don't necessarily need a lawyer for this. You just have to develop standard business practices to, ensure your information is kept confidential. And I would encourage every company to do that. So it becomes part of the institution, part of the culture, and you don't even have to think about it too much. Famous trade secret would be Coca-Cola, the actual formula for Coke, perhaps KFC, Kentucky Fried Chicken, the 7 special spices, and could be the way you make an item, a manufacturing process, could be a business method, the way you do business, a process for sales calls, for fulfilling your pipeline, and just corporate information such as customers, prices, etc. That's not in the public domain can all be subject to a trade secret. One thing I will just do a quick contrast between trade secrets and patents is the fundamental issue here is, do you want the public to know what you're doing? So if you have a special algorithm, say in artificial intelligence, some sort of a tweak, maybe how you pre-process data or something like that, which is novel, you may not want to file for a patent because part of the patent process is you must publicly disclose it, and it may be better protected by trade secrets. However, if something you're doing is conspicuous, such as a user interface feature or a physical item sold in the marketplace, clearly, the public and your competitors can see what you're doing. So in that situation, it's often better to apply for a patent or other forms of intellectual property as required or as applicable. Moving along, so there's a usual process for obtaining patents and trademarks. They're very similar, other than patents are typically more complex. Typically, you draft an application and you file it with the applicable government agency. Canada, it's CIPO, that's the Canadian Intellectual Property Office. United States, the USPTO, which is the United States Patent and Trademark Office. After some period of time, shorter with trademarks, longer with patents, an examiner at the office is going to look at it and is going to do a search. And they're going to do a search to determine if your patent is, if your invention is patentable in the case of a patent, or they're going to do a search on trademarks to see if it's distinctive. That means different enough from what else is in the marketplace. And typically they're going to look at the patent database and the trademark database. And so basically they're going to do a search to determine whether or not your application is ready for issuance. And almost always, in the sense of a patent, almost always they're going to say no. And if you go through this process, don't be discouraged. That's very normal. They're going to do a search and say, well, if you combine these 3 inventions, we come up with your invention. But that's sort of, most inventions are incremental. And you have a chance to respond and try and convince the examiner that they're incorrect, and you can make your arguments. It's all done by writing, and this can be done several times back and forth between the examiner and the applicant. And oftentimes the patent claims are narrowed at this stage. I won't go into what that means, but you basically negotiate with the examiner at the patent office to determine some scope of patentability. Sometimes they won't budge, and you have a decision to make to either abandon the application or to continue it for certain strategic reasons. But oftentimes, your patent will issue. I'd say something about 50% last time I checked of inventions are granted a patent at some point in time after 2 to 3 or 4 years. If you are, fortunate to get a notice of allowance, that's basically the examiner says you can get it. You pay the registration fee, and your intellectual property will be registered and made publicly available, and you'll obviously get a registration number, and that will become part of your official portfolio. Something you should know is that maintenance fees must be paid periodically after issuance to the patent office or the trademark office. Otherwise, your rights will be abandoned. But those fees are relatively nominal. Okay, let's get into the interesting stuff. What are some strategies for startups? I'm a lawyer. I obviously want to generate business, but a lot of stuff can be done by a startup or internally without having to spend too much money on a lawyer. I would start with instilling a culture of pride and inventorship, and encourage the internal circulation of ideas amongst the proper teams. It develops a culture of innovation, sharing, and kind of encourages positive collisions in an organization, so that people are excited about what they're developing and want to share it with others. Incentivization, you can incentivize, certain teams. A lot of companies will, provide some sort of a bonus for intellectual property, or even just let people be aware of how, being an inventor of an issued patent can really help their career, especially if someone's interested in research, or if they want to become a founder themselves one day. And I think it's important to encourage your employees to want to grow with the company, and also eventually sometimes beyond the company. It helps encourage documentation. Nowadays, thankfully, things are often documented just through the normal course of emails, Slack messages, GitHub commits, right? But it does encourage documentation. This helps in many other areas other than intellectual property, such as SR&ED. That's a very, very valuable tax credit, which most companies are probably aware of. Maintaining technology in the technology stack in the future, and of course training new employees and so forth as they come on board and trying to understand the code base and contribute in their own way. And one thing I'd like to point out is nowadays there's often an open source culture amongst younger people and innovators, which I think is fantastic. So founders, other innovators don't want to necessarily encourage sort of stifling of competition or cease and desist letters and so forth. And I think that's a great way to think. But it can be accommodated, by sort of having something like an inventor's bill of rights, which would be sort of a commitment of a company to say, no, we're never going to stifle innovation. We're not going to get into lawsuits and so forth, unless one, we're sued, or two, there's a company or person which is blatantly stealing our stuff. So it's a commitment between the company and its employees to say, no, we're all for open source or growing, innovation in the larger ecosystem. And we're sort of committing not to getting involved in legal brouhahas unless we're absolutely put into a corner and we've done nothing to deserve this. Okay, in terms of, things you can do, as standard operating procedures, just make sure your legal documents are in a good state right from the beginning. I think this is standard stuff, so I would encourage you all, whether you need to spend a little money on a lawyer or just get the right precedents yourself, often incubators will provide them for you, is just make sure in every single employment agreement and contractor agreement, that's really important, people that are on contract, make sure that intellectual property is assigned to the company. Any IP they develop in the course of their employment or contract should be owned by the company. It's very important. You don't want to have to run around trying to get people to sign stuff after they left and sometimes leave on poor terms. And also make sure that you have confidentiality provisions in your employment agreement as well. Quick story, company I worked for, we sold it to a really large tech company, and we had our IP agreements pretty good situation. But at the same time, when this company was going to buy us, their lawyers said, we want IP assignment clauses from all your former employees, and you have to go around the world trying to get people to, sign documents. And after people leave, whether it's good terms or not, they're often busy and they're not into signing agreements. So it's just important to just get, if it's part of an employment agreement, it's a standard term. No one should get their back up about this. Just make sure the intellectual property is assigned as part of the standard employment agreement. Use NDAs for third-party discussions. And I say read them. Read them, obviously, you're going to know your own NDA, but sometimes it's provided by the other party. I say that because larger companies, strategic partners, they'll often say you must mark your information as confidential. Otherwise, it's not protected by the NDA. Typically, startups don't walk around with all their information marked as confidential. So I would say read that to make sure you know your obligations. Obviously, in some certain cases, you don't want to have to even bring up an NDA. Often when you're talking to VCs, potential investors, they don't want you to bring that up, and that's fine. But whenever you're talking to a strategic partner, if you tell them something, they can take it, and then they're not actually taking it. You just disclose it to them. So I would encourage you to always have a simple NDA of your own, and then to read the NDAs provided by potential partners. And kind of going back to the first point, get assignments signed before every application, patent application or trademark application. An assignment is just the company, pardon me, the employer, employee, or a contractor says, yes, the company owns this patent application or the technology covered by this application. Otherwise, it's a pain to round them up later when people move on and you want to get further investment and your investors or your acquirer says, we want to see all your assignments. Better to have it all set and just make it a part of your standard operating procedures. You don't need a lawyer for this. Maybe you might need a lawyer to create some of these documents, but internally you could have someone that, administers this, whether it's a founder or if you're larger, just an administrator that helps with these documents, and it becomes just standard process and it's not a big deal. Okay, moving on to strategy. Tax lawyers have a phrase that taxes deferred are taxes saved. So the longer you can defer costs, the better it is for everybody. The best way to do that for a startup is something called a provisional patent in the United States. It's quick, informal application, not disclosed to the public. It's patent pending for 12 months, and it gives you 12 months to try and market the invention, raise cash, etc., in which to file in the United States a regular application or in Canada or other countries, and they will claim priority from the provisional, meaning they get the same filing date as a year before of the provisional. I hope this is clear to everyone. Basically, it allows you to get a patent on file for relatively cheap, get a patent number for 12 months, a patent application number, and then you have 12 months to determine whether you want to spend some real cash. And of course, if you raise $3, $4, $5 million in the meantime, it may very well be worth it to spend the money at the end of 12 months, but you don't have to shoulder a significant upfront cost. So that's a real powerful way to get a patent on file. Canada and the United States have a 1-year grace period before filing, which means that this is separate from the provisional. You can disclose your invention, and then you have one to the public for various reasons. You might just want to sell it to people without the subject of an NDA. You have 12 months in which to file in Canada and the United States. It's another way to to basically sell your invention, try and generate some cash or some publicity, and you still have 12 months in which to file. There is a very important note here. Most of the world has something called absolute novelty standard, which means that if you disclose it to the public, your patent rights are gone. So this 1-year grace period only exists, to my knowledge, in Canada and the United States. But for certain purposes, it's worth disclosing it to the public and waiting that year to file a real patent. And then international treaties are your friend. 1 year to file in most countries. This is under the Paris Convention. Basically, if you file in a certain country, you have another year to file in all the other countries that are party to the convention, which is most of the countries of the world. And a patent cooperation treaty, you may have heard of something called an international patent. There is no such thing as an international patent. There's such thing of an international patent application, which allows you to file in a treaty country patent office or the World Intellectual Property Organization in Switzerland. And then you have a long period of time in which to file in each country, sometimes up to 4 years. So again, it allows you to defer costs for a long period of time. That's only if you have significant funding and your invention is of wide global scope and you want patents in several countries. Common pitfalls to watch out for. The big one is public disclosure, because it destroys your chance of a patent in almost all the world other than Canada and the United States. So if you disclose something to the public, oftentimes it's worth it, but just know that you have a year in Canada and the United States in which to file a patent for something which is disclosed to the public, but for the rest of the world, your patent rights are essentially have been abandoned. Number two here, I say, however, if you want to keep something secret, again, patents and trade secrets are almost the opposite end of the spectrum. If you want to keep something secret, then you don't want to file a patent, because as part of the patent application, you must disclose it to the public. So again, certain types of sensitive algorithms, chemical formula, the Coke formula, etc., a certain way of manufacturing something, you may want to keep it secret and not file for a patent. Make sure you list all inventors. This is really critical for a patent application. Patents are filed not in the name of a company. They're filed in the name of the inventors, even if it's owned by a company. The reason you want that is because if you don't include an inventor and they come out of the woodwork years later, they can really legally extort you, to be honest, or prevent you from being acquired or getting funding by saying, hey, I own this invention. So just make sure all the inventors are listed and the proper documentation is signed before you file a patent. That's basically number 4. And number 5, I know the innovators don't always have time to know the law, and that's why you hire lawyers. But just know that if you hear something in US and Canada, it does not apply to the entire world, particularly if it's disclosed your patent rights are gone, and there is no such thing as an international patent. There's such thing as an international patent application, which can lead to patents in many countries, but there's no international patent. And that's all we have for today, is a very, very high level overview. I have some other slides here if you want to get into key legislation and constitutional authority of intellectual property in Canada and the United States. Interesting cases, very interesting cases, which we can circulate this to the group. Early statutes and the evolution of intellectual property from Venice, the Republic of Venice, and from United Kingdom several hundred years ago, and then international treaties, the main ones for various forms of intellectual property. Anyways, now I'm going to open the floor to questions, and I'll turn it over to May, who is moderating.
Excellent. Thank you so much, Rob, for the amazing presentation and sharing your knowledge. Do we have any questions so far from the audience? Okay, Sajid, what are my legal remedies if someone breaches a patent?
Oh, that's a great question, Sajid. I didn't expect it to get so heavy in this presentation. Basically, there's, someone is essentially at that point infringed your property. They're using your property as if it was real property without your permission, as if they were, using your car without your permission. Obviously, if someone's using your car, you call the police. That's not the situation here. You can sue them is really the long and short of your legal remedies. Before you do that, of course, I would, recommend that you start out with some letters of progressive aggressiveness, cease and desist letters, essentially, and let them know the consequences of what they're doing, and that they must cease and desist immediately. It's often important to kind of hold out a carrot with the first letter to say, hey, you're willing to talk to them about appropriate licensing fees. That's the case sometimes, unless someone's clearly just a competitor stealing your technology. You probably wouldn't even want to negotiate a licensing deal. But if it's not an actual competitor, but a potential partners, you could reach out with a carrot and say, hey, let's talk about royalties. If they insist on doing it, you can sue them, and you can actually go to, through the Superior Court or the federal court. You can, pursue an injunction and get a court order to force them to stop. That's a really, really important remedy in significant patent cases. That's actually why BlackBerry, when it was a much larger player in the smartphone industry, eventually paid $650 million plus to a company called NTP, because there was an injunction coming down where BlackBerry essentially was going to have to turn off its service to its customers, and in particular, the Department of National Defense in the United States. So that was an injunction that was going to be enforced, and they just simply had to pay to settle that lawsuit. So yeah, you can start with a letter writing campaign, let them know you're willing to do a deal if there's a deal to be had, and eventually you can initiate a lawsuit and pursue an injunction in significant cases. Injunction, for those who don't know, is essentially a court order which can be enforced by the police, which is going to force them to stop doing what is said in the court order, essentially using your technology. Hope that's helpful. Any additional questions?
An additional question, I think you partially answered. Can I get money or compensation from the breaching party for their breach?
Oh, absolutely. There's really two ways to do that. And one would be, there's, again, through a cease and desist letter, there's some sort of a royalty or licensing deal worked out between the company that owns the IP and the company which is infringing it. And otherwise, the way to do that is essentially pursue a lawsuit. And you will, if you're victorious, it does take several years. Everyone should know that, although it can be done by small claims court in smaller cases, but in any case of a significant value, through the federal court system or the Superior Court, provincial courts, you can sue them and eventually get judgment, and they will have to pay the damages that the court awards. In the United States, they have something called treble damages, which means that they can evaluate for the economic impact on you and award 3 times the actual damages to the plaintiff if someone's infringed your IP. And that's why, in the United States in particular, it becomes a very, very important when you're doing business in that market to make sure that, one, you're protecting your IP, yourself, and two, that you're not infringing, to the best you can figure that out, other companies' IP. And as much as it'd be nice in a way to live in a world without this stuff, the reality is the United States is heavily litigious, and if you're lucky enough to be very successful, you're going to infringe other people's IP, even innocently. It's just the way technology is, and you want enough of a portfolio for yourself to be able to kind of negotiate out of that if you have to, or defend yourself if you're unwittingly end up in some litigation. But that means you're very successful at that point, so it's not the end of the world. But it helps to be proactive and make sure you have a portfolio of value for yourself as well, so you're in a better position to deal with those unfortunate situations.
Thank you for that. Let's see this other question. If you develop something patentable with help from others, can you get a patent in your own name exclusively?
Great question. Absolutely great question. And so obviously there's nothing specific there, so I will talk at a very, very general level, which is what the question is about. It really comes down to whether or not they're an inventor. An inventor is someone who contributed inventively to the invention. I know that's a lot of the word invent in there. What that really means is, did the person exercise skill and judgment together with yourself, that person, or others in creating the invention? The best way to explain it would be just to contrast it with something that's not inventive. If I create a new item, a physical item, it's brand new, no one else has done it, it performs some function, and I tell someone to make it according to my blueprints, they're not an inventor. If I tell them to test it according to my standards, they're not an inventor. However, if I say, can you design something that does X, and they come up with something inventive in the design, then they would be an inventor. And likely I would be an inventor as well. So it really depends on the scope of their contribution. If they did something that has the spark of inventiveness or uniqueness, then they should be listed as an inventor. Otherwise, they could create all kinds of negative consequences in the future. I understand why you might not want to, but that's but really, to protect yourself, you should get all inventors should be listed as inventors. But if you're the only person that created the real spark of innovation, and other people just kind of acted under your instructions with sort of more routine tasks to implement it, then they would not be inventors.
Great. Now, the final question. This more so comes from myself, is if a startup comes to you with a patent or an idea they want to patent, what
Sure.
kind of information do you need from them to start the process and to, like, I guess, what would the roadmap look like?
Well, what I would typically do, if it was a provisional patent, which is a more informal patent application in the United States, which also can be protected after 12 months in Canada, the United States, and other countries, I would ask for, I do have like a checklist, worksheet I can send out, which is really long, but really I want them to describe, what is the essence of the invention, and what is the problem in the market? What are the shortcomings of the competition or what's already out there? And why is your idea, your invention, better than what exists? That's really what I need. Again, it's a big checklist I can send out, and I do send out. But what I ask people to focus on is, tell me what's cool about it. Tell me why your invention is better than what is out there, and why it solves a problem that exists that is not currently solved. Either it's better or literally nothing else exists. So that's really what I need to know, is what's innovative about it, and what problem does it solve, and how does it solve it?
Okay, thank you very much. Do you see
And just so, sorry, May, if it's a provisional patent application, again, it only has to be 3 or 4 pages long. I mean, pictures are good, flowcharts are good. User manuals can be good. All kinds of things can be added as an appendix. And then it's not publicly disclosed right away. And we have 12 months to determine whether or not we want to submit a formal patent application. In the meantime, your patent pending. So obviously, if it's software, unless it's user interface, pictures don't help that much. But if it's a physical item or hardware, pictures can help, but flowcharts can help. And just a description in your own words about why this is better than what exists, what problem does it solve, and how does it solve it? That's the key information.
Excellent. And I see there's more questions here, but we are scheduled to close off soon. So if somebody want to work with you for future reference, how would they do so?
Oh, well, I mean, just feel free to get in touch at robert@mackey.law or check out the website and reach out. I mean, I'm happy to have a call. I'm happy to talk to you about your issues on there can be some free time built in, and then we can determine, what you need and how we can best assist you. But just reach out and happy to have a call about your business. You can use me as a sounding board. I work with a lot of different startups. Obviously, everything is perfectly confidential, but when it comes to investment, acquisitions, licensing, contractual issues, and unfortunately, part of doing business is things will happen. There's always going to be the odd employment thing that goes wrong. There's always going to be the odd licensing issue which goes wrong. There might be issues between founders that happen. These are just the normal things that happen. I've seen basically all these issues, and I'm a solutions-based person. We want to solve these issues. We want to be positive, preserve the value of the company, and move forward. And I can help you with that.
Excellent. Thank you so much for the presentation and sharing your knowledge again. Digital round of applause for Robert. Thank you all for attending, and we will close this off now, but it's recorded and we'll send out the recording after for future reference.
Okay.
So thank you again, and wonderful
presentation. Everyone, and thanks, May, very much.
Excellent. All right. Bye-bye.
Bye-bye.